Warm greetings everyone. I am Dr. Purnima Khanna from Khalsa College of Law, Amritsar. My dear learners, in the present module, we will discuss the Guardians and Wards Act 1819. The learning outcomes of the present module are, firstly, the introduction of the topic, secondly, significant provisions of the Act, third, factors to be considered by the court when appointing guardians. We will also learn about the powers of a guardian and finally the conclusion. Before the detailed discussion, let's have a brief overview of the topic. Now, all children deserve due care, protection and facilities to ensure the overall development of their personalities. A healthy and secure upbringing is essential for the physical, mental, psychological and social well-being of a growing child. A child, due to his or her tender age, is dependent on elders. The significant role played by elders gave rise to the legal concept of guardianship. Guardianship refers to a bundle of rights and powers that an adult has in relation to the person and the property of a minor. In the present module, we will discuss the concept of guardianship as provided under the Guardians and Wards Act 1890. The Guardians and Wards Act 1890 is a secular law regulating questions of guardianship and custody for all children within the territory of India, irrespective of their religion. It is an umbrella piece of legislation that supplements the personal laws governing guardianship issues under every religion. Even if the substantive law applied to a certain case is the personal law of the parties, the procedural law applicable is what is laid down in the Guardians and Wards Act 1890. Dear fellows, let's go through some of the important definitions. Section 4 of the Act explains various terms. Firstly, minor. Minor means a person who, under the provisions of the Indian Majority Act 1875, is to be deemed not to have attained his majority. Second is guardian. Guardian means a person having the care of a person, of a minor, of his property or of both his person and property. Then ward. Ward means a minor for whose person or property or both there is a guardian. As far as power of the court to make order as to guardianship is concerned, Section 7 of the Act provides that the court may make an order appointing a guardian of a minor's person or property or both, or declaring a person to be guardian of a minor, where it is satisfied that such an order is necessary for the welfare of a minor. An order in this direction shall imply the removal of any guardian who has not been appointed by will or other instrument or appointed or declared earlier by the court. Who are the persons to apply for guardianship? An application for an appointment as guardian can be made by following persons. Firstly, the person desirous of being or claiming to be the guardian of the minor, or any relative or friend of the minor, or the collector of the district or other local area within which the minor ordinarily resides, or in which he has property, or it can be filed by the collector who has authority with respect to the class to which the minor belongs. Now, the court having jurisdiction to entertain application of guardianship, Section 9 provides that if the application is with respect to the guardianship of the person of the minor, it shall be made to the district court having jurisdiction in the place where the minor ordinarily resides. Further, if the application is with respect to the guardianship of the property of the minor, it may be made either to the district court having jurisdiction in the place where the minor ordinarily resides, or to a district court having jurisdiction in a place where he has property. Moving further, now let's understand the form of application. Section 10 states that if the application is not made by the collector, it shall be by the petition, signed and verified in the manner prescribed by Code of Civil Procedure for the purpose of signing and verification of a plaint, and further states so far as can be ascertained the name, sex, religion, date of birth and ordinary residence of the minor. Further, where the minor is a female, whether she is married, and if so, the name and age of her husband. It shall also tell the nature, situation and approximate value of the property, if any, of the minor. It shall tell about the name and residence of the person having custody or possession of the person or property of the minor. What is the near relationships the minor has and where they reside. The application form shall also tell whether a guardian of the person or property or both of the minor has been appointed by any person entitled or claiming to be entitled by the law to which the minor is subjected to make such an appointment. It shall also clarify whether an application has at any time been made to the court or to any other court with respect to the guardianship of the person or property or both of the minor, and if so, when, to what court and with what result. Whether the application is for the appointment or declaration of a guardian of the person of the minor, of his property or of both shall also be clarified. Where the application is to appoint a guardian, what are the qualifications of the proposed guardian? It shall also tell whether the application is to declare a person to be a guardian, the grounds on which that person claims. Then the causes that have led to the making of the applications. So all these particulars shall be clarified in the application. Power to make interim orders for production of minors and interim protection of person and property. Section 12 of the Act postulates that the court may direct that the person having custody of the minor shall produce him at such place and time before such person as it appoints, and may make an order for the temporary custody and protection of the person or property of the minor as it thinks proper. Now, I will highlight the factors to be considered by the court when appointing guardians. Section 17 of the Act lays down the factors to be considered by the court when appointing guardians. The court shall be guided by what the personal law of the minor provides and what in the circumstances of the case appears to be the welfare of the minor. Furthermore, it is provided that in determining what is for the welfare of the minor, courts shall consider the age, sex and religion of the minor, the character and capacity of the proposed guardian, and how closely related the proposed guardian is to the minor. The wishes, if any, of the deceased parents and any existing or previous relation of the proposed guardian with the person or property of the minor. If the minor is old enough to form an intelligent opinion, the court may consider his or her preference. Now, best interest of the child in international human rights law. While the welfare of the child principle dominates the domestic legal framework, a comparable legal standard is found in international human rights law. According to the United Nations Convention on the Rights of the Child, in all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities, or legislative bodies, the best interest of the child shall be the primary consideration. The Convention directs the state parties to ensure that both parents have common responsibilities for the upbringing and development of the child. The Convention provides that a child should be separated from his or her parents if there is abuse or neglect of the child by the parents, or where the parents are living separately and a decision must be made as to the child's place of residence. The welfare of the child as a criteria for decision is generally flexible, adaptable and reflective of contemporary attitudes regarding family within society. The Committee on the Rights of the Child has provided additional guidance regarding the best interest standard in its General Comment 14. The committee stated that it is useful to draw a non-exhaustive and non-hierarchical list of elements that could be included in a best interest assessment by any decision maker having to determine a child's best interests. The committee suggested that the following considerations can be relevant: the child's views, the child's identity such as sex, sexual orientation, national origin, religion and beliefs, cultural identity and personality. Also, the preservation of the family environment and maintaining relations, including where appropriate extended family or community is there. The care, protection and safety of the child. Any situation of vulnerability, disability, minority status, homelessness, victim of abuse, etc. shall be considered. And the child's right to health and right to education are also important factors. Cases where the court may not appoint a guardian. Section 19 of the Guardians and Wards Act 1890 deals with the cases where the court may not appoint a guardian. Section 19B states that a court is not authorized to appoint a guardian to the person of a minor whose father or mother is alive and who in the opinion of the court is not unfit to be a guardian. The earlier section 19B prevented the court from appointing a guardian in cases where the father of the minor was alive. This clause was amended by the Personal Laws Amendment Act 2010 and was made applicable to cases where even the mother was alive, thus removing the preferential position of the father. Fiduciary relationship of guardian to ward. Section 20 states that a guardian stands in a fiduciary relation to his ward, and save as provided by the will or other instrument, he must not make any profit out of his office. Another question is about capacity of minors to act as guardians. According to section 21 of the Act, a minor is incompetent to act as guardian of any minor except his own wife or child, or where he is managing member of an undivided Hindu family, the wife or child or another minor member of that family. Remuneration for the guardian. Section 22 provides that a guardian appointed or declared by the court shall be entitled to such allowance, if any, as the court thinks fit for his care and pains in the execution of his duties. When an officer of the government, as such officer, is so appointed or declared to be a guardian, such fees shall be paid to the government out of the property of the ward, as the state government by general or special orders directs. Regarding the duties of the guardian of the person, Section 24 lays down that a guardian of the person of a ward is charged with the custody of the ward and must look to his support, health, education and such other matters as the law to which the ward is subject. Authority of the guardians over the custody of the ward. Section 25 of the Act deals with the authority of the guardian over the custody of the ward. Section 25 Clause 1 states that if a ward leaves or is removed from the custody of the guardian, the court can issue an order for the ward's return if it is of the opinion that it is for the welfare of the ward to be returned to the custody of the guardian. Analyzing these provisions together, it can be concluded that in appointing a guardian to the person or property of a minor under the Guardians and Wards Act 1890, the courts are to be guided by the concern for the welfare of the minor or ward. At the same time, the implication of Section 19 Clause B is that unless the court finds the father or mother to be particularly unfit to be a guardian, it cannot exercise its authority to appoint anyone else as the guardian. Thus, the power of the court to act in furtherance of the welfare of the minor must be deferred to the authority of the parent to act as guardian. Removal of wards from jurisdiction. Section 26 mandates that a guardian of the person appointed or declared by the court, unless he is the collector or is a guardian appointed by will or other instrument, shall not without the leave of the court by which he was appointed remove the ward from the limits of the court's jurisdiction. Duties of the guardian of property. Section 27 states that a guardian of the property of a ward is bound to deal with it as carefully as a man of ordinary prudence would deal with it if it were his own. He may do all acts that are reasonable and proper for the realization, protection, or benefit of the property. Powers of the testamentary guardian. Section 28 states that where a guardian has been appointed by will or other instrument, his power to mortgage, charge, or transfer by sale, gift, exchange, or otherwise immovable property belonging to his ward is subjected to any restriction that may be imposed by the instrument. A disposal of immovable property by a guardian without the permission of the court is voidable at the instance of any person affected thereby. Limitations of powers of guardians of property appointed or declared by the court. Section 29 postulates that where a person has been appointed or declared by the court to be guardian of the property of a ward, he shall not, without the previous permission of the court, mortgage or charge or transfer by sale, gift, exchange, or otherwise any part of the immovable property of his ward, or lease any part of that property for a term exceeding 5 years or for any term extending more than 1 year beyond the date on which the ward will cease to be a minor. A disposal of immovable property by a guardian without the permission of the court is voidable at the instance of any other person affected thereby. Then comes alienation of a minor's property. Section 30 mandates that permission for the guardian to alienate the minor's property shall not be granted by the court except in cases of necessity or for an evident advantage to the ward. The order granting the permission shall recite the necessity or advantage as the case may be, and describe the property with respect to which the act permitted is to be done. The order may specify such conditions as the court may say fit to attach to the permission. The court may impose following conditions while giving permission. Number 1, that a sale shall not be completed without the sanction of the court. That a sale shall be made to the highest bidder by public auction before the court or some person specially appointed by the court for that purpose at a time and place to be specified by the court. That a lease shall not be made in consideration of a premium or shall be made for such a term of years and subjected to such rents and covenants as the court directs. That the whole or any part of the proceeds of the act permitted shall be paid into the court by the guardian to be dispersed therefrom or to be invested by the court. My dear learners, let's talk about judicial approach on the topic. The Supreme Court of India in Mosmi Ganguly versus Jayant Ganguly 2008 and almost all of the high courts have held that in custody disputes, the concern for the best interest or welfare of the child supersedes even the statutory provisions on the subject outlined above. While the older cases under the Guardians and Wards Act 1890 held that the father can be deprived of his position as the natural guardian only if he is found to be unfit for guardianship. There are many cases where the courts have made exceptions to this notion. In Sura Beddi versus Chima Reddy, 1950, the Madras High Court awarded custody to the mother based on welfare principle, even though the father was not found unfit to be a guardian. Courts have held that in deciding custody, children shall not be uprooted from their familiar surroundings just to give effect to father's right to natural guardianship. Further, in Satyendra Nath versus B. Chakrabarti, 1981, where both parents of the child were dead and the paternal relations claimed custody of the child who was residing with the maternal relations. The Calcutta High Court held that the welfare of the minor was the paramount concern and the paternal relations did not have any preferential position in matters of custody. What is the difference between guardianship and custody? The law governing custody of children is closely linked with that of guardianship. The term custody is not defined in any Indian family law, whether secular or religious. The legal difference between custody and guardianship can be illustrated by an example that's under some religious personal laws. For very young children, the mother is preferred to be the custodian, but the father always remains the natural guardian. For example, in case of Muslim law, it may be summed up that the Guardians and Wards Act 1890 is a secular law regulating the guardianship and custody of the minors. The main objective of the guardianship is to ensure the welfare and protection of the minor's person and property, as the minor child is incapable of taking care of himself or making decisions. With this, we come to the end of today's lecture. Thank you very much.